Good morning, everyone. Thank you for tuning into our show, Moving to Australia with Amitava Deb. With me in the studio this week is Amitava Deb, the founder of Debika Migration Services. And in today's podcast, we will be talking about visa conditions, what they are, why they matter, and what should one be cognizant of. Warm welcome to you, Amitava. How was your weekend?
Good morning, Arun. I had a good weekend. How was yours?
It was good. We went to Terrigal Beach.
Which beach?
Terrigal Beach.
Oh, Terrigal. That's nice, isn't it?
Yeah. We have a lot of good beaches here in Central Coast.
Mm-hmm.
Last week when we spoke, you mentioned that every visa except a PR comes with certain conditions when granted.
Yes.
Some conditions always apply and some may apply depending on a range of criteria. So talk to me about what these conditions are and how can one verify which conditions apply to their in effect visa?
Mm-hmm. So every visa comes with a condition which can be viewed on the visa grant letter or using online VEVO. On the visa grant letter, look out for a 4-digit number or a series of 4-digit numbers. They start with 8. So visa conditions are part of Schedule 8 of migration regulations. And they keep changing, they keep amending, but largely conditions are there to ensure that the visa which is granted to a person is with certain restrictions, certain rights and responsibilities which must be adhered to. For example, subclass 491, which is regional migration. So subclass 491 has conditions. What do you think would be the most predictable condition on 491?
Work restrictions? Because it's a regional visa.
Yes, that's it. So it needs to be in the person, the holder of the visa must be living and working, and if they're studying, they must be studying in a regional area.
So can you expand on that? If someone has to work in a regional area, does that mean that the company that they work for cannot be headquartered out of the regional area that they're in?
So the company may be based elsewhere. The company may be based in a non-regional area, as long as the company agrees in writing that the person can work out of their regional offices or even out of their home. Yeah, because there are customers in that region. It is okay. It is allowed.
So if someone's living in Geelong and their office is in Melbourne and they're working remotely, that's acceptable.
As long as the company on their appointment letter writes that he will be based out of his home office in Geelong. And that could be for a variety of reasons. So that's okay.
Now, does living in a regional area restrict you from also traveling to, let's say, Sydney, Melbourne, or Brisbane for work-related activities such as training, workshops, meetings?
The condition doesn't mean that you are imprisoned. Business trips are allowed as long as you do not move physically to that non-regional location. There are people who, for example, live and work in Adelaide and travel frequently to Sydney, Melbourne, Brisbane, and that is perfectly allowed. You're not expected to sit at home all the time, right? And we can even go on holidays. That is okay. That's not a problem.
Would hybrid roles be a breach of this condition? Let's say that you work in a regional area three days out of the week, and the other 2 you have to be on site. Would that be a breach of the visa conditions? For 491 example.
Yes, of course. Hybrid is not allowed. You must be based completely out of a regional area. So this is one of the visa conditions, and the condition number usually is 8579. Live, study, and work in a designated regional area. Now, it is important to note, for example, in a family, for example, if there is the applicant, his spouse, and one child. If the entire family moves to Australia, they all individually must satisfy this condition. So it cannot be that the primary applicant, I'll come back to this, the term applicant, I didn't use the term visa holder. The primary applicant of the 491 visa, who now holds 491 visa, lives and works in Geelong. And he probably thinks that no, my child probably can work in also study in Melbourne. I will rent a house, my wife and my child will be based out of Melbourne. No, that is not allowed. So if they are in Australia, they all must satisfy that condition. If they are not in Australia, well, that's fine. So it may be that one of the applicants come to Australia, lives, works in a regional area to meet the condition, then brings the family for the second stage. That is perfectly allowed. Now, I just want to touch upon something. A lot of people think I am the primary visa holder. The visa holders, they're all equal. When you make a visa application, there is a primary visa applicant and there are secondary visa applicants. Once the visa is granted, everyone has a visa, that particular visa. There is no primary or secondary in the grant letter, which means if someone is holding 491, his spouse is holding 491, and the child holds 491, in the second stage of the visa, any of these can be the primary applicant for the PR. I just thought I'd touch upon that.
Second stage for someone with a 491 is
191 visa.
191. Okay.
Yeah. Now there are other conditions for 491. Let's not go away too much from the topic. One is 8515. It means you must not marry or enter into a de facto relationship before entry. What it means is that you got the visa, maybe you got the visa by claiming 10 points for being not married. So you need to enter, you need to make the first entry to Australia before you marry. Otherwise, the visa will be cancelled. The other three conditions are provide evidence of your live, study, or work address if requested. And in fact, they request quite frequently. Where are you living? Where are you working? If you're studying, where are you studying? And that must be responded to within the time frame requested.
How frequently does the Department of Home Affairs reach out to someone?
Quite frequently, happen quite frequently, 3 to 6 months, once every 3 to 6 months. Now, a lot of people ask this question. If they are nominated by one state, can they move to a regional area in another state? I think we did a podcast on this.
Yeah,
before.
last week we spoke about this.
Yeah, so the Department of Home Affairs do not care. They just care about these conditions. So these are examples where the conditions do not talk about any particular state. They talk about live, study, and work in a designated regional area. Condition 8579.
Now, at the start of the podcast, you did mention that one can find out about their visa conditions online on VEVO.
Yes.
Can you elaborate on what VEVO is for the benefit of our listeners who are not aware of it?
So VEVO stands for, I think it's verification.
Visa entitlement verification online. VEVO.
Sorry, yes, thank you. So you just Google VEVO, enter your visa details, and you will get the details of your visa. If you're onshore, it'll mention you're onshore. If you're offshore, it knows, the system knows. And at the bottom of the VEVO output, you will see all the conditions. They are exactly the same as what you would see on your grant letter.
Is there also a VEVO app?
Yes, it's called MyVevo. MYVEVO. One can download and keep it on their mobile.
All right.
So I just want to touch upon some of the visa subclasses where visa conditions are very important.
Sure, please go ahead.
One such visa would be student visa. So student visa comes with several conditions. One such condition would be work limitation. Work limitation implies that 8105, for example, implies that you cannot work more than 48 hours a fortnight when your course of study or training is in session. If it is out of session, you can work full time. So out of session means holidays, but it does not mean on the weekend it is out of session. One might interpret this saying, okay, well, Saturday, Sunday is out of session, I'll work full time now. In session means the entire duration when the course is in progress, you are supposed to be attending classes. It doesn't matter if it is once a week, twice a week, thrice a week. You cannot work more than 48 hours a fortnight. And that is condition 8105.
What else should students be aware of? Which other visa conditions?
There's another one, 8104, and that is 40 hours a fortnight. So one should carefully check, is it 8105 or 8104? Now, the family member of a visa holder who is studying masters or PhD, masters or higher, can work more than 48 hours a fortnight. So the family member, only if the student is studying masters or higher. There are other visa conditions. Limited study change, 8203. And that means that you must not change your course of study, thesis, or research topic without the approval of the department, without the approval of the minister, it says. Yeah. And there is a process for it. So a lot of people come here and they change their studies. So they cannot do that. Then there is 8204, that is known as study limitation. It says you must not undertake or change your study thesis research topic without approval of minister for a graduate certificate, graduate diploma, master's degree, doctorate. So there are all these limitations that are imposed. Then there is a condition. There are a whole bunch of conditions. I'm just highlighting the main ones. Then there is one which is 8532. This is a very important one. It says maintaining welfare arrangements for minors. If the student is less than 18 years of age, you must have accommodation and support, and your general welfare must be maintained for the duration.
For the duration of the study.
For the duration of the study. To maintain your welfare, you must stay in Australia with your parent or legal guardian or legal custodian, a relative who has been nominated by your parents, and have accommodation, support, and general welfare arrangements in place for the duration of the study. Of course, this also brings into another point. There is a student guardian visa. So if a minor applies for, say, school study, one of the parents can apply for student guardian visa for the welfare of the minor. But the student guardian on that visa cannot work. On that visa, he or she will not have any work rights. Then there are conditions like informing change of address, informing change. So the change of address is 8533. Maintain adequate health insurance, 8501. Not be disruptive. This was recently, not recently, but not couple of years back, it was introduced. It says you must not become involved in activities disruptive or violence threatening harm to the Australian community or a group within the Australian community. For example, engaging or promoting extremist views and interrupting the operation of the Australian community. So they're very strict. If someone comes here with an agenda, a political agenda, a right-wing, left-wing agenda, that is not allowed. You're here to study. Don't be disruptive, it says.
If a student violates the conditions imposed on their visa, let's say they work for more than 48 hours,
Mhm.
what happens?
If the department finds out, they will send a notice, a letter, saying we have been brought to our notice that you have breached this condition. Please provide a response why we should not cancel the visa. So they don't cancel the visa. They give an opportunity to the student to provide a response. I have been involved in one of those cases. There was a girl who was in early childhood and she was not supposed to work for the duration of Christmas because the session was on or something like that. I can't remember. And she received a notice. And we then argued that she was not aware of this particular issue and we did a petition. It was accepted. So it's not all end of story if a notice is given. If there is a breach, it depends on the circumstances and it can be waived as well.
Now, there's a lot of people who travel from Europe and North America to Australia on a work and holiday visa and working holiday visa.
Mhm.
Can we touch upon certain conditions that they should be aware of?
Working holiday visa is for 417, I think. Yeah, 417 working holiday. So the working holiday visa has quite a number of instances. There's the first one, then there's the second one. So each of these will have its own set of conditions. So let's talk about subclass 417, which is the one commonly used by Europeans. The conditions are 8106, work limitation. You cannot work in Australia unless it is relevant to the business or tasks specified in the visa, or 8107 if you are allowed to work for a particular employer. So they could. These are not mandatory conditions. Some conditions are mandatory, others are not. Then there is this condition about adequate health insurance, not arrive before a person specified in the visa. So if there are two people who have got the visa, then one of them must arrive before the other one. No further stay. 8503 means if they are in Australia, they cannot apply for another visa. They have to leave the country and then apply. There could be a condition called 8548, maximum 4 month study. 8547 is so this is I think this one is the most common one, 8547, not work for one employer for more than 6 months. But I think during COVID that uh, restriction was lifted. And then if you are applying for the second one, then there are conditions. The conditions are that, no, this is a precondition, sorry, prerequisite. Prerequisite is all about where that person has worked. Has he worked in a regional area, a designated area? Then only he can apply for the second one, working holiday visa. But I think the conditions are more or less the same. It's the same for 8547. Do not work for one employer for more than 6 months. Of course, one can take permission in writing that they need to work for the same employer, or if the employer has a business in a different location, the applicant move to another location and work. That is allowed.
Do you see any of these conditions imposed on parent visa as well?
Parent visa, which one? The PR? PR has no condition. But there is a sponsored parent temporary visa 87T. 870 has a few conditions. One is no paid work, 8103. So they can do voluntary work, but not paid work. Not be disruptive. Again, parents cannot come and be engage in any um, activities that is disruptive to the community. 8501, maintain adequate health insurance. 8531, must leave before visa expiry. Now, I want to touch upon this one and 8503. 8503 is no further stay. No further stay means one cannot stay here beyond the expiry of the visa and cannot apply for another visa to stay here unless they apply for a waiver. So one can apply for a waiver of no further stay. This particular one, 8531, imposed for parents holding 870 visa, must leave before visa expiry means if the visa is allowed to expire and the person has stayed here, then he or she is in breach of that visa condition. So would you know, Arun, how someone can circumvent this particular condition?
No, I've never been in that situation, so I won't know.
So suppose the parent's visa expires on 30th of April, okay? And the condition says 8531 must leave before visa expiry. If that parent applies for another visa onshore, because he or she is allowed to do that, and the visa is granted before the expiry of the current visa, then the current visa is gone. It doesn't expire because it's been overwritten by the new visa. So this condition is wiped away. I also want to talk about 600. 600 is visitor visa. So visitor visa has several conditions attached. One is no work, mandatorily it will be put. One who is on a visitor visa cannot work, voluntary or involuntary, no work permitted. 8201, maximum 3 months stay. Sorry, maximum 3 months study. So on a visitor visa, one can study, but up to a period of 3 months. 8503, no further stay. No further stay is discretionary. It may be imposed, it may not be imposed. But if it is sponsored family stream, it will be imposed. 8503 means the person cannot apply for another visa while in Australia. They must leave. And then 8531 is must leave before visa expiry. And this is which I explained earlier. If they do not have no further stay, but must leave before visa expiry, they can apply for another visa, get granted, and then they do not have to leave.
So let's extend this discussion a bit more for parent visa. If someone wants to bring their parents to Australia permanently, then what is it that they should avoid doing?
If they want to bring the parent permanently to Australia and the parent applies in India or in the country where they are, God help them because it's going to take 50 years. So a lot of people, what they do, they bring their parents into Australia, apply onshore and get bridging visa granted, which then allows them to stay here until a decision is made. But there are two things here. One, one of the parent must be 67 or above, which means they must be of pensionable age. Only then, when they apply onshore for a parent visa, onshore aged parent visa, onshore aged contributory parent visa, they will get granted a bridging visa. Okay. But back to your question, what should they keep in mind when bringing their parents? I guess they should get their parents not on sponsored family stream. If the parents are brought on sponsored family stream, they will have condition 8503, which means they cannot apply for any other onshore parent visa. unless they apply for a waiver, and it's very difficult to get the waiver approved. They should always therefore apply for subclass 600 visitor visa tourism stream.
Can you share an example of a client that you had in the past who were not aware of visa conditions imposed on them when they decided to move to Australia and then they had trouble extending their stay here?
Yeah, so it's mainly the condition 8503, no further stay. When they come here, they think they can apply for onshore visa, but because of 8503, they cannot. They have to go back. During COVID, of course, getting a waiver on 8503 was easier, but COVID is gone, so we are back to where we were. It's always advisable not to apply under sponsored family stream if you are planning to bring your parents onshore and apply for another visa.
Sounds good. So if there's any other visa subclass that you want to touch upon.
I think these are the main ones. I spoke about student visa, sponsored parent visa, visitor visa, working holiday visa, and subclass 491. I think these are the main ones.
Okay, then I guess we can wrap up this podcast. Thank you for your time. And for those of you who want more information about visa conditions and want to have a detailed discussion with Amitava, the link to Amitava's LinkedIn profile is in the podcast description. You can visit our website and call us, or you can email us and someone will get in touch with you. Thank you for listening, folks, and see you next week. Goodbye.
Thanks, Arun. Bye-bye.